What is up? Truth and transparent. What is going on? Woo!
How about a doorbell that can scare package thieves away?
Cheers, Wednesday night. Oh. Look at how long my hair is. It's the longest it's been in a while. I'm getting it, when do I go in? What's it, Friday, I think? I can't remember. What's today, Wednesday? Hey, hey, hey. It's burnt as hell. Be kind in chat, love. I'm winding down my Wednesday. Sorry for the delay. Only about 10 hours. How have you guys been? Hey to the moon and back. Howdy, howdy, howdy. You guys been good? Just talk about life. What's been going on? Everybody's kids back to school. Jack started kindergarten. Yep. My little bundle of joy. Hello, Modbod's favorite peeps of mine. Kylene, what is up? Bumblebee. Maybe I got a song for you tonight, Bumblebee. Oh, I've been busy, guys. I'm sure you guys have been wondering about my life. I just worked an 11-hour shift. I'm just spent, yeah, me too. I spent, let's see, 9 to 9. I spent 12 hours doing shit I shouldn't have to do, but Boston. I got so much sun this past weekend. I must say, Lana, you are saying my name like a true, yeah, I am. Am I? What's up, Boston? Hey, TNT fam. What's up, Tasha? Yeah, I got burnt. I shouldn't say burnt. Whatever. Spent some time on boats and hoes. Muffy, Jackie, oh my god, look at all these familiar names. I can't say faces because shit. Hello, beautiful Anna. Hello to everybody in chat. Be kind in chat, love. This is Sheldon's post-sentence motions that were filed. I'll briefly talk about some of them. I made it again, guys, in case you guys care. What? Yes, that's an exhibit. But top-notch written work here by Corey Woods. He outdid himself here. So I'll talk about a couple things with with that, I'll talk about some bombshell discovery. I mean, pretty bombish. And September 25th is the podcast debut of season 2, episode 1. Remember, all those episodes are pre-recorded once a week. It'll be like a premiere, and then there'll be live chat, obviously for the premiere when you're watching it. And then 2 days later, we'll feature like a Q&A about the episode if people had questions. Trying to think what else. I've been doing a lot of editing, researching, editing, filming, writing. So yeah, these episodes are all like pre-recorded because it matters. I think they're gonna be great. I think you guys are gonna enjoy them. I had the pleasure of talking to Jamie Brown's attorney today, Andrew, for like a good hour. I'll be in Aliquippa this coming weekend at some point. I gotta handle some stuff here though. So, what else is good in the hood? Like I said, Jack just started school, so I wanted to spend some time with him before school started. So we went over to Port Clinton and Put-in-Bay. Did, the water life. Before that, I was in Florida. I was not homeless by any means, right here, obviously. Same place. I have been busting my ass. Thank you, Boston. I'm enjoying a glass of wine to, like I said, wind down. Today's been long. Got to keep up my tan for September 25th. If you are close enough that you want to drive or fly, you should come to the red carpet party, September 25th. Oh, thank you, Mike Drop Mama, letting us know that it's been a very long day. New moon. It was actually beautiful weather here, though. It was like 70, breezy, like, woo. So, with Pennsylvania law and how the post, like every state's different. So something really quick is like in, Colorado, how Chris was filing a 35C. That's the name of the motion. But in Pennsylvania, what has happened so far in Sheldon's case was we tried to get a 704B brief, which is extraordinary circumstances right before sentencing, that the judge could, after, a verdict has been read, can basically throw out the verdict, declare a mistrial, possibly even throw it all out and overturn it. But Kim Tesla, the odds of him doing that just because of who he is was very small. Obviously, he did not do that, and then went ahead forward with sentencing, and then it puts Sheldon into the post-conviction, journey path, where he no longer has the attorneys that he had for trial. They're working with Mr. Woods, here and there with stuff, but Corey Woods is his counsel on record. Corey Woods is top 3 in PA, Pittsburgh, Beaver County area for what is needed. And how do I want to say this? There's different phases and at different times in your, if you're in Pennsylvania, there's different times when you can go ahead and file things like your direct appeal, an appeal for ineffective counsel. So that doesn't all go into this. And that's kind of what I'm going to talk about briefly, is what is actually in this motion, this post-sentence motion. But everything that you ever need to talk about at some point during the process has to be at some point up until this point talked about. Otherwise, you have grounds later on to bring that up. So the verbiage and the writing and the language that you use in this is so critical, because otherwise down the road you won't be able to, you know, talk about something that if you don't bring it up now. So hopefully, I'm just trying to give it to you guys ABC level, first grade level. See. Ooh. I will come to Massachusetts, don't worry. Who doesn't love, I told Boston she has to take me to the fish. I get fish. I want to get clams, crab legs, everything seafood for like 4 days straight. Just kill it. Go live. Okay, so in this, the big part of it is the juror. Okay. Corey Woods brings up, mind you, this is 53 pages. Like that. Okay, so number 1 is the motion for an evidentiary hearing or a new trial based on improper outside influence of a jury. So right here, number 1, motion for an evidentiary hearing and or new trial. This is what they tried to get, okay, Tesla to do and have an evidentiary hearing before even just saying, like, I'm gonna, deny your motion. So something that Mr. Woods mentions that I don't think was hit enough on by, trial attorneys was during voir dire, that is when people that it could be potential jurors are questioned. During voir dire, flat out, this juror lied. No doubt about it. John Paul could say whatever he wants, okay? And that media and Beaver can try to spin it every which way possible. But you get the transcripts and you read the transcripts. Your neighbor was gunned down, 9 bullets. Your husband at the time saw the body. We'll get to that. But that is somebody that you knew that was a victim of a, heinous crime, and that was asked of her, and she said no. So during this process of selecting the jury, this honorable court and counsel attempted to ensure that the trial would proceed via the jury's application of the law, as this honorable court announced it to the facts as the jury and only the jury found them, based on the admittance evidence, and that's only the admitted evidence. So you can't talk to anybody, you can't pray on it, you can't, read a newspaper, like things of that nature. None of that was allowed. And this task was very sensitive, considering, and very important, because Jeter had previously been widely publicly reported as a person of interest in the extremely high-profile investigation of the 2018 homicide of Rachel Del Tondo, one of the most infamous crimes in Beaver County. And in fact, reports regarding this case referenced his status in that regard. So, it was very important to get the jury right because of the 2018 highly publicized, so everything to do with questioning those juror members, huge because of Jeter's name. To that end, throughout the questioning, and bearing in mind that asking directly about the Del Tondo investigation could prompt jurors to connect Jeter to the Del Tondo investigation where they would not otherwise may have done so. So that's where it becomes strategy upon what his trial lawyers were saying, is that we can't flat out ask. The trial lawyers' strategy was to not mention Del Tondo at all. Don't let them, we can't bring her up. We don't want the jury to put two and two together, the possible jurors to put two and two together. But we can ask questions in a way that was their strategy. So with that being said, though, that is considered counsel's way of representing Mr. Jeter. So that's like, does that constitute as grounds for ineffective counsel because of what they did or didn't do in the questioning during to come with the jurors? So the honorable court and counsel discreetly inquired. So it wasn't just, this is what Corey Woods is saying, is that it wasn't just the attorneys that were being discreet, the court was discreet. So the honorable court and counsel discreetly inquired in a general fashion as to whether prospective jurors had heard anything in the media about the case. And then he references, so what Corey really did really well is he's got so much case law in here, and case law is everything. You can't just say, hey, this is this and not give them a reason. You have to like cite sources, and that's all what case law is. That's where when you're looking stuff up to be like, okay, I know this is, it's an entrapment, like find something on it. So he put something in here where it says, notably, the inquiries in this regard revealed numerous jurors familiar with Jeter's connection to the Del Tondo investigation, all of whom were stricken for cause and or via they used their peremptory challenge and they were excused. So basically what Corey is alluding to here is that if this juror would have told the truth, she would have been immediately, just like everybody else to that point and during this whole process, was ixnayed. She tells the truth, ixnayed. It gets better. Additionally, throughout questioning and the trial, this honorable court routinely and emphatically told the jurors to disregard any media, any coverage, to refrain from discussing the case in any respect with anyone. Nevertheless, after the verdict, Jeter's counsel learned that this honorable court and their efforts to ensure the integrity of the verdict had been undermined by these facts. A, at the time of the Del Tondo homicide, juror number 3 and her now estranged husband, I'm not going to say his name, lived with her parents next door to the crime scene and were actually present when the crime occurred. B, at the time of the Del Tondo homicide, juror number 3's husband viewed Del Tondo's body, which contributed to his development of post-traumatic stress disorder, which in turn contributed to juror number 3's and Smith and who he's married to. This is why he was estranged, and this is why they were getting divorced. Due to his PTSD after this incident. At or around the time of the Del Tondo homicide, juror number 3 authored social media posts about the crime, and in the years since appears to have followed the investigation and views it as having contributed to her and her husband's estrangement and divorce. She made posts about it via social media. And guess what, guys? That's all provable. Why is this clicking on and off? And then mid-trial, based in part on her recognition of some of Jeter's family members in the gallery, juror number 3 identified Jeter as a person of interest in the Del Tondo investigation. This is during mid-trial. E, that during trial, 2 individuals loudly discussed the Del Tondo investigation within earshots of jurors, including juror number 3. And then F, that the night before the verdict, juror number 3 stayed with her father, still living next door to the Del Tondos, talked about the case with him, talked about having difficulty deciding whether to vote to convict or, acquit Jeter, prayed with him for guidance, and made her decision that night prior to the end of deliberations. This is real. Accordingly, on July 20, 2021, Jeter's counsel filed a brief in support of forthcoming oral motion for extraordinary relief. That's what they put in the day before sentencing, and attaching affidavits from individuals with first, second, and third-hand knowledge of the foregoing. Okay, so what you are allowed to do, and this is important to explain, you're allowed to submit affidavits, and hearsay can be in it because an affidavit is getting you to the point of allowing you to have an evidentiary hearing. Okay, now we need to subpoena the person that actually made those statements and see what they're going to say. Does that make sense? So that's the whole point, is that, Judge Kim Tesla did not interpret the law correctly. And while he was talking, actually at sentencing, about stuff like this, he misinterpreted the law, and it's going to come out. I know this might be boring for some of you guys, but this is actually really important for Jeter in terms of or for anybody in the situation, the verbiage and the language that you use. Otherwise, you're not getting back into the courtroom. You're not getting a new trial. You don't do this part. Doesn't matter. Just a copy of the brief and exhibits is attached here as Exhibit A, and these are all things that have been talked about because of the prior motion. Now, something I thought was awesome. What Corey has done here is just, I'm sorry, case law after case law of showing that this is what the courts did when something like this has happened. It's called precedent. You're going to follow case law. So on July 21st, Jeter proceeded to a sentencing hearing at which Jeter's counsel made this said oral motion for extraordinary relief. At the hearing, like I said, they denied the motion as insignificant to satisfy the requirements for extraordinary relief, but without prejudice to Jeter's right to reassert the same or related issues in post-sentence motions. And this is where we're at. So it was summarized. It basically denied without even looking at it. That's basically what Tesla did. So he didn't really even look at it. He just went through the motions with that, but he did say, but this is being denied without prejudice because you're going to go ahead and do all of this. I'm just giving you extraordinary relief. I am not, he made it perfectly clear, I am not interrupting the course of sentencing. now where Judge Tesla misinterpreted the law, is you have 90 days in which to sentence somebody. So when he says, in his words, I'm not delaying the sentencing process, that's a misinterpretation of the law, and you look like a fool saying that, because you're not delaying the sentencing process. Just because you put the sentencing date at 3 to 4 weeks after the verdict, that's what you did. Jeter can be sentenced up to 90 days after being found guilty in that, with that trial. So there would have been when I sat in that courtroom and I heard him say, I am not delaying sentencing. You're not delaying sentencing. You have 90 days to sentence somebody. It's not even been 30. Like, what are you talking about? So, regardless, he was sentencing. He was not going to basically say, I'm not granting a mistrial because of this right here, right now. I'm sentencing Jeter. That's what's happening, and you guys are going to go follow through with this. So, here we go. No state shall deprive any persons, this is Corey, no state shall deprive any persons of life, liberty, or property without due process of law. Again, this is the United States Constitution, blah, blah. He's signing it. And then during what I just kind of read here, he also cites a couple other things, which is number 2, juror number 3, in regard to the matter, which is when, where was it up here? Where did he put it? 3, 3, 3, 3, 3, 2, 2, 2, 2, 2, 2. Was it back here? Juror number 3, in this regard, not only failed to disclose plainly information during voir dire and at trial, but also actively violated this honorable court's repeated instructions to refrain from discussing the case with anyone. Juror number 3 was also less than forthcoming in response to numerous other inquiries. Number 3, specifically, Jeter previously tendered, and herein renews his tender of affidavits from, I'm not going to say their names. There's 3 people, though. Thus far, the federal and Pennsylvania constitutional rights to trial by jury appear to have been interpreted incorrectly. Moving on. Number 17, a criminal defendant has a right to, quote unquote, trial by an impartial jury, i.e., a trial based upon the jurors' applications of the law as the court announces it, to the facts as the jury finds them, based on the evidence at trial, rather than, quote unquote, outside influences. As a matter of due process of law, and he references Parker, there's a case there. Parker versus Gladen, it was a 1966 case. See also Commonwealth versus Engelberg. That's a PA case, 1987. Number 18, thus in Pennsylvania, a defendant who learns that he was tried in part on the basis of outside influence may seek and obtain an evidentiary hearing by demonstrating, including by more general hearsay materials, which that's what I was trying to talk about. You're allowed to put hearsay in, and then you just subpoena people, and then they then say whether or not it's true. But you're allowed to, including by more general hearsay materials, that there is a potential judicial question to that end, and maintain a new trial by demonstrating by competent evidence that the outside influence was of a nature objectively reasonably likely to cause him prejudice. So if outside influences influenced the jury and it caused prejudice against Mr. Jeter, this would constitute a new trial, okay? And then he says, see generally Pratt versus St. Christopher's Hospital. It was a PA case, 2005. So he is citing all over the place. This is this, this is this. This is why we should be having an evidentiary hearing. This is why you get somebody and you have to pay the big bucks to get somebody to do this for you. You can't write something like this. You just can't. But when someone doesn't think about this, if Jeter didn't have Corey Woods, who's going to write this for him? You think Jeter's going to write this for himself? No. If he did, I mean, guys, he couldn't. He doesn't have the first clue. Number 19. This is a two-step process. I'm sorry, this is a two-step inquiry. First, importantly, a defendant may rely on more general hearsay materials to raise a potential judicial question as to outside influence. I'm sorry, I just read that. Didn't I? Losing my mind. No, I didn't. Yeah, a defendant may rely on more general hearsay materials to raise a potential juror question as to outside influence. The reason for this evidentiary leeway is that litigants and counsel are discouraged from interrogating jurors ex parte in an effort to find evidence that might impeach on adverse verdict. Again, see Pratt 866. Again, he's referencing. But it also consists with practical reality that counsel lacks the authority to compel a person or a potential witness to swear out an affidavit, whereas counsel can compel a witness's testimony at an evidentiary hearing. So when you're asking for an evidentiary hearing, then that's where you're going to get the witness testimony. So Judge Tesla just throwing out an evidentiary hearing is like, you have to grant this. You're allowed to grant evidence. That's the whole point of an evidentiary hearing. Think about this when Jeter was first, arrested. And then you have to go through the steps of everything. Okay? You have an evidentiary hearing to see if there's evidence for him to even be going to trial. Like what evidence do you have against Mr. Jeter to be in this situation? So it's no different here. Here, this is the stuff that we're bringing to the table, but with this evidentiary hearing, then you can subpoena these people, then they get on a stand, and then you ask them questions about the affidavit that they wrote. You're going to subpoena somebody like the juror's husband and ask him, because we're going to get a little further and to see where he says stuff. In Pratt, so he's referencing, he's casing, in Pratt, a medical malpractice case, for example, after a defense verdict, one of the jurors wrote a letter to the court indicating that other jurors had engaged in conversations about the duty of care and particular alleged breaches thereof in the case with third-party medical professionals. So he is referencing this case and citing and saying that while they were deliberating, these people on the jury were like, oh, we went and asked other medical professionals about what this is all about in the medical field. A general triple hearsay statement suggests an outside influence. So this juror writes a letter claiming that other jurors during deliberation told this juror, hey, we went and talked to these other medical professionals and asked them what they thought about this case. Okay, so that would be, that's triple hearsay, right? Well, guess what? They got an evidentiary hearing out of it. On appeal, the defendants argued that the letter did not warrant an evidentiary hearing, but our Supreme Court, in an opinion authored by then Justice Later Chief Justice, now Justice Thomas G. Saylor, rejected the argument, noting that more leeway was required at the pre-hearing procedural stages because it had previously basically told the litigants and attorneys not to give firsthand knowledge. And it, again, gives a huge case, just a description of how that whole case went. We acknowledge appellant's argument that Juror 10's affidavit lacks specific material in respect, and therefore, even if believed, would not in and of itself establish the quantum of prejudice necessary to disturb the verdict. For example, it's not specific in terms of whether the extra record information allegedly communicated to jurors was favorable or unfavorable. So it goes on to read all of this, citing this case, and ultimately that was overturned. Like, it was that triple hearsay was the leeway needed to allow an evidentiary hearing. So it overcame 2 case law sightings. It said, given such constraints, the Superior Court did not err in determining that Juror 10's affidavit was sufficient to implicate further investigation by the trial court via an evidentiary hearing. As noted above, Jeter previously tendered, and herein renounced that materials raised judicial questions as to whether Juror number 3 was subjected to outside influence arises from her experience with the Del Tondo homicide and investigation, her conversations with others about the same, or her conversations with her father and potentially God about the case. Again, he's citing more cases. Thus, Jeter should be granted an evidentiary hearing on this claim. At a hearing, a defendant must then demonstrate by competent, admissible evidence that the outside influence creates an objective likelihood of prejudice. So everything that Corey Woods is citing here is case law showing that the Superior Court, trial courts, even if the trial court said no, the Superior Court then said yes to the evidentiary hearing, which Kim Tesla basically didn't even look at. Again, Jeter previously tendered, because I think I told you guys this, which I was really disappointed when Kim Tesla brought this up. He literally in court says, I mean, these affidavits that you guys are submitting, this is just a bunch of hearsay. I mean, how do we know that they weren't talking about what they're going to make for dinner tomorrow night? This is what he said in court. Like, it was bad. It was like, what are you talking about? That's the whole purpose of the evidentiary hearing, is to like ask them what they talked about, But this guy who's supposed to be like by the book says, well, this is just all hearsay, and I'm not even gonna. These are affidavits that were submitted by 2 lawyers, Kim Tesla. Like, these aren't just like people were pulled off the streets to like fill out an affidavit. These 2 out of the 3 affidavits were signed by lawyers, number 1. Number 2, you're wrong about hearsay, because hearsay has nothing to do with, like, you're allowed to have hearsay in an affidavit. And hearsay, hello, it's all the law right here. Like, what are you doing, Tesla? Shitting the bed. It's right here. So again, Jeter previously tendered, and here, all this blah, blah, that these 3 people, in their affidavits, Jeter further notes that although the affidavits rely on hearsay statements, he has no means to compel, them thereof to swear out an affidavit. Whereas if granted an evidentiary hearing, he will have the authority to and intends to compel testimony. So that's what this is all about, is that there is hearsay in here, but hearsay will get you the evidentiary hearing. Then everybody can go ahead and be, compelled to testify. He's also going to then determine whether outside influences or an outside influence is prejudicial. A trial judge must determine how an objective, typical juror would be affected by such an influence. This is good right here. This is probably my favorite part about it. So basically, where Corey's going with this right now is he is really honed in on the affidavit that, and I can just say this because I think it's public knowledge, the affidavit that one of his trial lawyers submitted. She was the one that talked to the family of the juror, okay? And this is what they told her. So now I'm gonna let Corey's words do the talking because it's really, really good. Carter by Carter versus U.S. Steel Corp. See also Pratt 866. Although application of that test at this juncture is speculative, it stands to reason that there is a reasonable likelihood that a typical juror subjected to such outside influences would cause a defendant prejudice by deciding to convict on an improper basis. Indeed, it stands to reason that if the typical juror learned that the defendant was a person of interest in an unsolved murder that occurred outside her home and may have led to the destruction of her marriage, there is a reasonable likelihood that she would convict on the improper basis that the defendant is rumored to have committed a previous similar infamous crime. Citing Commonwealth for Santiago, PA 1974. Holding mistrial required where witness for the Commonwealth informed two jurors of his view that defendant had previously killed a different person, or on the improper basis that she views him as responsible for her personal difficulties. So something that has not been talked about, and this is a big bombshell, is that this juror blames Sheldon Jeter for her marriage, like no longer having a marriage and him going estranged because that he killed Rachel Del Tondo, he got away with it. Her husband had to see the body and got post-traumatic stress and all the PTSD, all this stuff, and that they started struggling in their marriage, and because of how the murder happened, and it's like, you wrecked my marriage, you murdered my neighbor, you're guilty. If you don't think that that's going to, I don't know, sway somebody to, not mentioning that all the lying that she did during, being asked questions. Do you know of anybody that's been a victim of a crime? No. Okay, sounds good. But that Rachel, all of this has led to, like, your marriage is over, and you're blaming. So of course, what are you gonna do? Say he's not guilty? No, this is definitely gonna cause bias and prejudice, and it's just. But what he is alluding to is that you have to question the juror and ask her these questions, and that's something that Jeter. That's what this is all about. Jeter can't do that. The courts have to. Similarly, it stands to reason that if the typical juror conferred with her father and God and made the decision to convict prior to the end of deliberations, there is not simply a reasonable likelihood of prejudice, but she has caused the defendant prejudice by prejudging the case, which is Commonwealth versus Benaglio, PA Superior or Super 1978, holding mistrial required where victim's brother engaged in conversations with prospective jurors prior to or during voir dire. Accordingly, in light of the following, Jeter respectfully requests that this honorable court enter an order granting him an evidentiary hearing on his claim and ultimately a new trial. So that's number one. That's number one. Yeah, you can, God, state, church, everything's separate. Number two is the motion to vacate conviction and judgment of sentence. Challenge the, it's like the qualitative sufficiency of this evidence of identity. This is about, okay, how do I want to say this? Why is this thing doing that? Let me just pause for a second because I threw a bunch at you. Does anybody have any questions? Yeah, I want to know who sent out the, let's just go to Buchanan Street and send out some juror slips. Whatever. Mike Droppin's got a question. Rachel's neighbor, yeah. Hi Natalie, missed you too. Did the new lawyer and team look to find out? We'll get into all of that stuff, but this is the stuff that matters now. Like, that's all handled. We already know that he didn't do it, and we just gotta get back into the courtroom. So, number one was everything I just talked about. Number two is the motion to vacate conviction and judgment of sentence. As noted above, Jeter proceeded to a jury trial and was convicted of first-degree murder. At trial, the Commonwealth pursued a less than comprehensive theory that after two family members and Pugh had ice cream earlier in the day, Jeter, for some unknown and unspecified reason, drove Pugh to Plan 6, shot him to death on a public street, returned home, and went to bed. This is good. This is what you need to listen to. Okay, so again, this is the motion to vacate conviction and judgment of sentence. Challenge the quantity, the quality of the evidence. It was brought to my attention, and it was so well stated. Anna, when's the last time that you've ever read like a discovery or read, trial transcripts, and at the end of reading the whole trial transcript that you would ask yourself, wait a second, what happened? Like, what happened? Okay, Pugh's dead, but what happened? Like, you know how, like, if you're with the Christopher Watts case, okay, what happened that day? What happened that day? And that's the same thing in this case. Like, wait a second, well, what happened? I read through all of this, and there's, like, Pugh's dead, but how did this all happen? And they never like said what happened. It's crazy. And this is what he's saying, is that at trial, the Commonwealth pursued a less than comprehensive theory that listen to this, after Jeter, 2 family members, and Pugh went to get ice cream, Jeter then, for some unknown and unspecified reason, drove Pugh to Plan 6, shot him to death on a public street, returned home, and went to bed. In support of this undeveloped and this is his wording. In support of this undeveloped and facially bizarre theory, the Commonwealth offered absolutely no direct evidence whatsoever and offered only the following circumstantial evidence to substantiate that Jeter was the perpetrator. A, evidence that Jeter's car, among many others, was seen going to and from the scene of the crime. B, testimony from a expert firearm and tool mark officer that some of the spent shell casings recovered from the scene were of the same commercial brand, Federal, as the ammunition recovered from Jeter's home, and that bullet fragments recovered from Pugh, quote unquote, matched a weapon and ammunition recovered from Jeter's home. C, evidence that there was gunshot residue in Jeter's car. D, testimony that when officers came to Jeter's home to inform him of Pugh's death, despite their not telling Jeter that Pugh had been shot, he was overheard on the phone telling another individual that Pugh had been shot. And E, testimony that Jeter made inconsistent statements about his and Pugh's whereabouts at or about the time of the murder. This is what these state. This is their case against Jeter. Those 5 points that I just said, you can roll it back. Although the Commonwealth is permitted to proceed entirely via circumstantial evidence and rely on reasonable inferences therefrom, it may rely on circumstantial evidence that more likely than not establishes a resulting proposition. It may not rely on evidence which is so inherently ambiguous, incredible, or vague as to be incredible as a matter of law, and may not rely on unreasonable inferences which are more properly termed speculation and conjecture, and may not rely on evidence that, as a whole, is equally consistent with the defendant's innocence. See generally Commonwealth v. Brown, PA 2012, PA 2016, and County Court of Ulster v. Allen, 1979. Although the above detailed evidence may be sufficient to place Jeter at the scene of the murder, nothing in the Commonwealth's case credibly establishes or permits a reasonable inference that he perpetrated the murder, rather than he was merely present at the scene, or, put another way, is more consistent with his guilt than his innocence, more specifically. A, regarding the evidence that Jeter's car, among many others, was seen going to and from the scene of the crime, such evidence does not make it more likely than not that he perpetrated the murder, and is equally consistent with his mere presence. B, regarding the testimony from an expert firearms and tool mark officer that some of the spent shell casings recovered from the scene were of the same commercial brand, Federal, and that it matched a weapon and ammunition recovered from Jeter's home, as Jeter's counsel deftly demonstrated at trial the expert's testimony lacked any significant foundation whatsoever, and that it operated on the base principle that items quote unquote matched when there was significant argument between experimental and controlled materials. And significant argument, quote unquote, was circularly defined as enough agreement to rule out other sources with absolutely no mathematical or scientific basis, rendering the sum whole of the testimony speculative, and it's all pure conjunctual. He then cites the most amazing shit I've ever seen here and says, it also bears noting that Federal Premium Ammunition is the world's largest seller of ammunition. According to Federal Ammunition on why bigger is better, take a look at this 2019 article. He is citing this article that that's like saying Pampers diaper. Okay, Pampers. Well, Pampers is the biggest selling diaper. A Pampers diaper was there. Okay, well, everybody has Pampers. Pampers is the number one selling. I mean, what do you want Jeter to buy when he was bought his gun? I mean, that's just... More importantly, then he says, which I died, he then not only cites that it's the most, like, it's the biggest brand. He then cites, indeed, Federal Ammunition is available for purchase at 7 locations within 10 miles of the crime scene, and 17 locations within 20 miles. See General Ammo Store Locator, and then he cited this. Last visited August 19th, 2021. Thus, the evidentiary pre-force of this expert's testimony on the subject is decidedly weak. He says, bitch is weak. I was dead at that. I mean, this is his language. I'm like, this is tits. This is so good. Indeed, in the identical content of the microscopic hair analysis, our Supreme Court, in any other opinion authored by Justice Saylor, has testifying examiners that they should not be testifying that one hair, quote unquote, matches another, but rather must acknowledge, quote unquote, acknowledge the inherent limitations of their field and avoid the forms of over-claiming and overstatements that have long plagued criminal cases, including this one. See Commonwealth versus Chimmel in PA 2020. See also the National Research Council Committee of Identifying Needs of the Forensic Science Community, Strengthening Forensic Science in the United States, A Path Forward, submitted to the United States Department of Justice 2009. I mean, he's just killing these sources and citing and just, I mean, just killing it. No pun intended, I mean, sorry. Detailing firearms and tool market examinations, there's so many flaws to that. Hypothetic, like the testing, he cites it all here, and I'm just like, woo, Corey, you're just rocking my box. I mean, this is like orgasmic to me. Like reading this, I'm just like, whoa. C is regarding the evidence that there was gunshot residue in Jeter's car. Again, such evidence does not make it more likely than not that he perpetrated the murder and is equally consistent with his mere presence. So D, regarding the testimony that when officers came to Jeter's home to inform him of Pugh's death, despite their not telling Jeter that Pugh had been shot, he was overheard on the phone telling another individual that Pugh had been shot. Again, such evidence does not make it more likely than not that he perpetrated the murder and is equally consistent with his mere presence. Regarding testimony that Jeter made inconsistent statements about his and Pugh's whereabouts at or about the time of the murder, such evidence does not make it more likely than not that he perpetrated the murder and is equally consistent with his presence and desire to obscure the same. At bottom, the Commonwealth simply has a hole in its case, i.e. a lack of evidence as to what exactly happened in Plan 6 on the night in question, and has attempted to backfill it with innuendo and junk science that rests on a circular premises. Look that up. Look up the word circular premises. Put it in, rockin' my box. Oh, I love that saying. Cheers, rockin' my box, core. Hopefully he's enjoying his vacation. At bottom, the Commonwealth simply has a hole in its case. A lack of evidence as to what exactly happened in Plan 6 on the night in question, and has attempted to backfill with innuendo and junk science that rests on a circular premises. In light of the foregoing, Jeter respectfully requests that this honorable court enter an order vacating his conviction and judgment of sentence and discharging him forthwith. Yeah, he is good. He is good. The psych baths. Well, clearly she's not with you. Number 3, motion for a new trial. Motion for a new trial. Challenge to the weight of the evidence. Again, this is number 3. Toss him. Make him make another name. Oh. Here we go. Again, this is motion for a new trial. Challenge the weight of the evidence. Again, he did 1. I read that 2. Now this is the 3rd major point to his amazing motion here. As noted above, Jeter proceeded to a jury trial and was convicted of first-degree murder. Again, at trial, the Commonwealth pursued a less than comprehensive theory, like that I said, that Jeter, 2 family members, and Pugh went and had ice cream. Jeter, for some unknown reason, and drove to Plan 6, shot him to death on a public street, returned home, and went to bed. Again, in support of this undeveloped and bizarre theory, the Commonwealth offered absolutely no direct evidence whatsoever, and offered only the following circumstantial evidence to substantiate that Jeter was the perpetrator. A. Evidence that Jeter's car, among many others, was seen going to and from the scene of the crime. Testimony that an officer came home. I read that one. Okay. In addition to the evidentiary weakness highlighted in paragraph 33 above, such evidence was further undermined by other essentially it was unreviewed, it was unrebutted, but this needs to be on record, and Corey's making it known right here. So again, in addition to the evidentiary weaknesses highlighted in paragraph 33 above, such evidence was further undermined by other essentially unrebutted evidence of record, which is A, regarding the testimony from an expert, quote unquote, an expert firearms and tool mark officer, that some of the spell, you know, I read all that, how that worked. Regarding the evidence that the gunshot residue in Jeter's car, such evidence was perfectly capable to resort to evidence that he had access to recently firing that shotgun that his brother had. Yes, baby. Why are you still up? Hang tight, y'all. Hey, Goops. What's wrong? Sorry about that. I have a feeling that may have been... Nah. Okay. Sorry that people got kicked off. All right, I'm gonna zip through this last part because we're almost done. Literally, like this is like the last page. And then I'm gonna go cuddle my man because he was missing me. I guess he woke up. He said he was dreaming of dinosaurs and his friend, he doesn't know his name. He said his friend dropped his Star Wars tin, a lunch pail, and it dented it. And he had a dream about it. What? I love you. Okay. So he wants to bring these three things up, which are huge. And it's, you know, regarding the expert firearms and tool marks. He's saying that there was, yes, you got ammunition from Jeter's house that matched, and that was the Federal brand, which is the #1 selling brand. But what he wants to bring up and what it was never talked about, which was this part, because there was never an answer for this. And this is the part about the bullets. There was also evidence that other spent shell casings recovered from the scene were of a commercial brand Winchester, not recovered from Jeter's home. And then he cites it and says the Commonwealth attempted to blunt the evidentiary force of this evidence by suggesting the spent casings could have derived from another container of various branded ammunition. The argument is too clever by half, as it believes the Commonwealth's true purpose of suggesting that no matter what casings were recovered at the scene, they could have been Jeter's. This is not the stuff of proof, but of rank speculation. Rank speculation. Great word, rank. So basically what they're saying is, and this is what I talked about during the trial, like there's four casings that none of those were present in Jeter's home. And they said, oh, because they were spent. They look at it, he used them. Where's the box that he pulled them from? Because all the other boxes are there. This is their shit. Again, Corey is flexing on these bitches. Rank speculation. Regarding the evidence that there was gunshot residue in Jeter's car, such evidence was perfectly explained by resort to the evidence that he had access to a recent fired shotgun days before the murder. And which Corey did not even mention, but it will be mentioned in other things. because it's already been brought up. If something's already been brought up, he doesn't have to touch base on it here as long as it at some point was mentioned. Things like the tow truck driver. You work on brakes all day if you're a mechanic. If you touched and were in that vehicle to move it in any way, shape, or form, what do you think? Like, gunpowder is, the residue is the same as like brake pads and stuff like that. So all things I've already touched base on. But here's C. Regarding the testimony that when officers came to Jeter's home to inform him of Pugh's death, despite their not telling Jeter that Pugh had been shot, he was overheard on the phone telling another individual that Pugh had been shot. Such evidence is perfectly explained by resort to other evidence that he had earlier, remember, this is, I mean, I didn't even talk to Corey before seeing this part. But he's nailing it. Right here, this is everything. You're dismissing when these officers were talking to Jeter, and Jeter told them, my mom called me. Gunshots were heard. My mom always calls me. She calls, she wanted to know where Rev, my grandfather was. Hey, where are you? Are you okay? That's what she did every time. Gunshots. So Delsha calls Jeter. It's proven in phone records. It was shown in trial. And in Jeter's own words, when he was asked about it, Jeter used in reference to this. He's like, well, I just put 2 and 2 together. And the officer said, what are you talking about, 2 and 2 together? He's like, well, my mom called me earlier and said there was gunshots being fired and asked me if I was okay at 11:48. Showed him the phone. Here she called me. And so when he's referring and saying, well, I just put 2 and 2 together, like, this is in the police officer's report. Well, I just put 2 and 2 together. And he's like, what do you mean? What did you put 2 and 2? Well, my mom called me and said, are you okay? That we heard gunshots. You're at my house, asking about Pugh. I put 2 and 2 together that Pugh had been shot. He didn't say that Pugh was dead, motherfucker. He said Pugh had been shot. Okay? He didn't say dead. So then this is what Corey says. Corey then says, such evidence is perfectly acceptable, explainable by resort to other evidence that he had earlier spoken to his mother and learned that shots had been fired in the vicinity. In the vicinity. Additionally, at trial, there was evidence that prior to the murder, an unidentified individual summoned Pugh to Plan 6 for some type of financial transaction. 41. In light of the foregoing, Jeter submits that the verdict of guilty shocks the conscience and is contrary to the weight of the evidence. And then he cites here, number 8, the Commonwealth attempted, or I already talked about that, I think. Yeah. In light of the foregoing, Jeter respectfully requests that this honorable court enter an order granting him a new trial. Wherefore, in light of the foregoing, Jeter respectfully requests that this honorable court enter the attached order vacating his conviction and judgment of sentence, or in the alternative, the attached order granting him a new trial, or in the alternative, the attached order granting a hearing on this motion, which a date has been set, ladies and gentlemen. The DA's office, the prosecutors, they have until September 28th to answer this. I believe October 4th is the date for said here. So cheers to Corey. And then he added in all the exhibits of the 704. That's what he has here in the back. Was his, let's see where it's at. Yeah, the Appendix A, brief in support of 704B, oral motion, trial motion for extraordinary relief. So all of this after the fact was, but I mean, I think it's pretty good. I think it's, I mean, I don't know. But Mr. Woods, you rock. I mean, I don't know. What'd you guys think of it? YouTube. Where was his mom when she called him? Don't they live together? No, they have like 2 houses. So she was at her house. He was at Rev's. You guys, Jeter's 22 at the time when this happened. 22, yeah. Excellent news, phenomenal. Yeah, so what do you guys think about the written work? Shot and dead are 2 totally different scenarios. Yeah, he didn't say, oh, Pew's dead. That's not the language he used. He said, Pew's been shot. That's the language he used, shot. You know, don't you think that if he would, like, if you weren't talking about a huge slip up, oh yeah, Pew's been murdered. Pew's been shot. Yeah, I think it's great work. Praying for Jeter, his family, and all his loved ones during this time. New lawyer seems like he means business. Yeah, this is all Corey Woods does. He's hungry. You know, Sheldon Jeter, in my opinion, is the Jamie Brown 2.0, which that's what season 2 is all about, is showing everybody the Jamie Brown case from 2001 and showing the similarities along the way. They didn't say that a suppressor was used. That's what a witness said, and there was a million witnesses that said that there was no gunshots on Keel Street, that he could have been murdered somewhere else because all of the surrounding houses where the body was, everybody said, here, every house on Keel Street at the bottom of the hill, not a single person said they heard anything. Oh, I was home all night, I was doing my dishes. Didn't hear anything. He wasn't shot there, baby boy. Or girl, whoever you are. Clearly spying on the case. It's probably JP up in the house. Make him have another, hey, you know what? I think it's JP. Make him have another one. Make him create another one. I mean, I know how bad the Beaver County needs it to be, his narrative. It's just not, and he hasn't written 2 articles, or he hasn't, in 2 months. His name, by the way, is in this. It's in one of the affidavits. So, could that juror be held for her lies? Yeah, I mean, at that point, a lot of things can happen. I think though that when everything comes out here in this evidentiary hearing, I don't see the juror lying at this point. I think she's already come clean with everything, and you know, nobody wants to be responsible for something like this, because maybe you don't realize it, but subconsciously, like, this is what happened, and you look back and you're like, oh my God, maybe I did do it because of that. Like, I don't know, like, and maybe, you know, I had no right being on this, you know, I had no right being on this panel. I had no right being one of the jurors. It wasn't fair. You know, it just depends on what she's going to say and how she's going to say it. But not only that, but it kind of really doesn't matter what she says. Language is everything, changes the contents and changes the perception. Yeah. Yeah, that was my answer. Corey did phenomenal. Also, he touched on every single point you've previously made. Yep, and there's just so much more, but I've gone 79 minutes and 45 seconds now because I haven't even gotten to my bombshells of the discovery. But at least you guys got to see this part of it. So I'll do a part 2 here, and for those of you guys that live overseas, I'll get you guys in the afternoon. I gotta run though. Love you all so much. Take care. Bye bye.